All right, we're back again for more about contracts. Now specifically contracts, agreements that deal with the sale of property. So let's look at contracts for sale. Remember that the basics of contract law, those things that make a contract valid, are still going to be in place for any contract, whether it's your listing agreement, your agency agreements, and especially your contracts for sale. So don't lose sight of that original list of what it takes to make a contract valid. But now specifically, let's look at some of the legal characteristics of your sales contract. What is required? First off, we have that offer-counteroffer process. And once we have a mutual meeting of the minds and every contract is signed, sealed, and delivered, we always say that. It sounds kind of funny, but just signing the contract doesn't mean it's binding. The notice of the agreement has to be sent back to the offeror to make it binding. So let's think about that. If you are the seller and I am the agent working with the buyer making an offer on your property, we've gone back and forth and back and forth. My buyer finally gets your final offer to us in the form of a counteroffer and says, okay, fine, this is it. We can agree to all these terms. They sign off on it. And we go out to dinner to celebrate. My buyer's happy because we've signed the contract. I could still get a phone call from your agent that says, hey, we've accepted another offer. Well, why? Because I didn't deliver notice of their acceptance back to you, and that's the final step. So offers, counteroffers, and acceptance, and then delivery of that notice all makes that contract binding once all the terms are agreed to. So we've talked a little bit about bilateral and unilateral contracts, but this chapter is going to take a little bit deeper look at that. Bilateral, promise for a promise, two people making an agreement. Unilateral contract is only one promise, like options that we're going to get into. But whenever we're looking at the legal characteristics of a contract for sale, you need to remember that it is a bilateral contract. Both people are making certain promises, certain obligations, and both are required to act in exchange for some benefit from the other party. All contracts need to be in writing to be executed and also to be enforceable. And we also have to make sure that we have consideration in our contracts, as we discussed earlier. This chapter is going to go into also earnest money. Earnest money is sometimes mistaken for consideration, but in a second we're going to talk about exactly what earnest money is and why it's important in common practice. We all have to sign, or all contracts have to be signed by all parties to be valid also as a contract requirement. So how do we create a contract? Once we have offers, you have to have an offer to have a contract. Somebody has to make an offer to someone else for that offer to be agreed to. So offers and counteroffers are accepted, and then once we have that acceptance, the buyer has what we call equitable title. Now dust the cobwebs off of some of those original chapters. Remember when we talked about title? What is title? That concept of ownership. So does the buyer own the property yet? No, but we call it equitable title. Equitable, like equity. There's something financial to gain from that transaction. So equitable title means that I have a future monetary interest in the ownership of that property, and I'm said to have equitable title once I'm under contract to purchase that property later. It's another confusing term, so I'll go ahead and break it down for you a little bit. Also, if we're under contract, if the other party decides that they're not going to move forward and they're not going to act, I have the ability to file a suit for specific performance. I could take you to court to force you to act, because remember, these are mutual agreements and both parties are expected to perform. So let's look at earnest money. In common practice, if we've already said that contracts require consideration, but consideration is not always earnest money, then what is earnest money? Imagine again for a second that you've got your house for sale and I'm a buyer wanting to purchase that property. Remember, I'm going to have equity equitable title once you accept. So I have an interest in your property and what you do with it from this point, because I'm hoping that one day it's going to be mine. Wouldn't you want me to have some skin in the game? Put up something for you on behalf of the transaction to make sure that even if I don't follow through with my obligations, you could still have some type of financial benefit for the time that you've spent waiting for me to move forward. So in common practice, earnest money is something that's very reasonable and commonly accepted as what we call good faith money on behalf of the transaction. Typically, it's held in escrow by one of the real estate brokerages in a separate escrow account, which we'll talk about in a later chapter, but that is money set aside that belongs to someone else. It's not usually handed over directly to the seller, but it's set aside on behalf of the transaction as good faith money while the borrower moves forward with their process of completing the purchase of the property. Contract contingencies. There are some things in contracts. Remember we said it's a promise to move forward and both are required to act. But what if there's some outside situation that could stop me from acting? Maybe I'm only buying your house because a job transfer has me moving to Texas and I want to purchase your home in Texas. Well, if the job transfer doesn't go through, I'm not going to buy your house. So maybe I could have a job acceptance contingency in my offer that the purchase of this property is contingent upon me getting a job in your area. There's lots of contingencies we can include in contracts. Maybe I have another house to sell and I can't purchase your house if that one doesn't sell. So I could have a contingency on my current home selling before I can buy yours. But remember this, a contingency in a contract is an if-then provision. If then. If my house sells, then I'll buy your house. Remember, we still have a mutual agreement, but a contingency could say that maybe if I don't get financing, then I won't be able to buy your house. If we don't pass inspection, I won't be able to buy your house. So anytime you see a contingency, that's going to be an if-then statement that can be written in to a contract or as a contract provision. And there's lots of those that could potentially be included depending on the situation. And again, we'll learn more in real life practice. You just have to really be aware and listen out for those things that could be the basis of the buyer's decision making on a certain property, that if one of these other things has to happen before we can move forward, we need to know that from the beginning, because that would need to be in part of our contract if that's one of the provisions of the agreement. So what happens if there's a default? If for some reason the seller a week before closing says, never mind, I'm not going to close, I'm not going to show up, and I'm not going to allow you to come through and do inspections, I'm not going to let you come in and see the house anymore. If the seller defaults, the buyer could actually file a suit against the seller, could, even have a suit for specific performance. The seller's immediate remedy for a default is usually keeping the earnest money if the buyer decides not to move forward. But again, what does your contract say? So depending on the provisions independently written in your contract, it would let you know what immediate remedies for default, maybe in your state or according to the terms of your contract. But overall, there are some basic contract law remedies that are available whenever someone doesn't perform what they say they're going to perform in a contract. So your next section is contract provisions. There are lots of primary provisions in the contract, like who the parties are, if there's going to be any commission disbursements. All of the details in the transaction have to be laid out in the contract. Also, some other provisions that would be made would be things like whether or not you're going to have a home inspection. Maybe the property's on a well and a septic tank and we want to have somebody check those out. Maybe we're concerned that the air conditioning system might be older. We want an air conditioning inspection. So all of those could be contract provisions. Remember, everything that has to be done over the process of the carrying out of the closing and the purchase of that property would need to be agreed to in writing. So any contract provisions would have to be a part of our agreement to make sure everybody's on the same page and knows what is expected of the other parties. So next concept is an option. An option. Remember we said bilateral contracts, mutual promises, two parties making an agreement. An option is a little bit different. You've probably heard of an option to buy or even a lease with an option. By definition, what's an option? An option's a choice, right? So if I have an option contract, I basically have an agreement where I am buying the ability to make a choice. So if I have an option to buy a property, I am paying up front for the ability to make a decision later. So whenever I have an option, that is a unilateral contract, only one promise. Think about that. So I want to have an option to buy your property. We're going to agree to all the terms that if I decide to move forward with the purchase, you'll sell the house to me for $100,000. You'll pay $5,000 towards my closing cost, and I would buy the house within the next 6 months. So I would have a 6-month option to buy. But now if I decide not to buy, do you have any remedies? No, because I've paid for an option. Usually option money is set aside with that option contract. And like I said, I'm just paying for the ability to make a decision later. So options are unilateral, one-sided contract. If it's a unilateral, only one side, who do you think is making the promise? It's the seller that's making the promise. The seller is agreeing that if I as a buyer decide to move forward, they will sell me the house, but I just have the ability to postpone that decision and have a certain time frame to decide if I actually want to move forward. So it's a little bit complicated when you read it on the pages, but they can be fairly common. I want to make sure that you understand that concept, especially the unilateral part, and know that the seller is the one that has the definite ability and the guarantee of acting, and the buyer is the one who's purchasing the option. Another concept that you're going to see is contract for deed. Contract for deed. It's thrown into this chapter as a concept, but a contract for deed is a term for basically owner financing. That if I'm writing a contract to purchase a property, but I wouldn't be getting my own bank financing, I want the seller to take regular payments on that property, it would be a contract for deed. So owner financing seems to be a more familiar term, but a contract for deed would lay out all the provisions where the purchaser is basically paying the seller over time for the ability to purchase the property from them, and all of the terms would be laid out. This chapter is also going to talk about different interests and rights, and of course who has recourse if the other party defaults on your contract. So enjoy learning a little bit more about contracts for the purchase of property in this section, and we'll be back soon.